Morning, ladies and gentlemen, and welcome. For those of you who don't know me, I'm Ira Epstein, the Joint Chief Executive Officer and Managing Director of Fluxmans. I want to welcome you all here this morning. Thank you for joining us. I'm sure that you will find this morning's question and answer session useful, informative, and very relevant. Our panel today consists of Colin Strime and Danie Pretorius. Colin is my co-chief executive of Fluxmans. He is one of the leading attorneys in South Africa in commercial and corporate related litigation, insolvency law, insolvency related litigation, insolvency inquiries, business reconstructions, and turnarounds. Colin has authored many articles and is regularly requested to deliver lectures at conferences. I want to thank him for giving up his valuable time and for agreeing to join us here today. Danie has lectured in commercial law, estoppel, unjust enrichment at Rao. He completed his studies towards an LLM degree, which was conferred on him in 1989, long before I was born. He has practiced as an advocate at the Johannesburg Bar, where he specialized in commercial litigation and labor disputes. He's held the position of legal director on the operations board of a major company and as the group human resources and legal director on the main board of the same company. He now specializes in labor law and commercial litigation. He's also acted as a judge in the labor court, and he's a member of the Fluxmans Exco. And again, I thank him for his attendance with us today. I also want to thank all of you who submitted your questions ahead of today's session. It's still possible for you to submit questions via the online link, which should be present either at the top or the bottom of your screen. There should be a Q&A box with a question mark sign. If you click on the question mark, it should allow you to submit questions. We will have to see how much time we have to answer all the questions that are submitted. I apologize in advance if we don't get your question, as we may run out of time, because there are approximately 150 people who accepted today's invitation. So if everybody submits a question, we may very well not get through the allocated time, which is an hour. So without further ado, I will now turn to the questions. Colin, the first question I want to put to you is, the client has an investment in a business in the events industry, which is unlikely to recover in the next 24 months. He's a 40% shareholder and a non-executive director of this business, and he signed personal surety for the bank, along with his co-shareholders. The immediate impact has been a loss of 90% of the revenue for this business, and as you can imagine, the situation is not expected to change in the next 6 months. Currently, the cash reserves allow the business to pay its operating costs, staff, rental, insurance, etc. And hopefully it will do this for the next 6 months. But in addition, there are certain accounts payable due to suppliers and bank loans which just simply cannot be serviced. What are the key questions to ask in taking the decision to follow the route of whether to go the business rescue scenario or liquidation as a result of the COVID-19 impact on the revenue on his business?
Ira, the first question is there a business that can be rescued? And is there a future for the company? If the answer is no to that, then obviously the advice is to go into liquidation. If the business can be rescued, and in whatever way the rescue may take the form, then obviously you've got to go for rescue. So you've got to sit down and analyze the business. You've got to see whether it has the support of all the key players, such as the suppliers, the customers, the banks, that there's enough finance to carry it through, that there's a plan that has a reasonable prospect of succeeding and turning the company around and making it solvent. It sounds like this company is commercially insolvent in that, although it can function now, it looks like in a very short term, it's going to run out of cash and then be unable to pay its debts. So first question, is your business capable of surviving if there is a plan that could be put into play?
So Colin, would you recommend that he goes and contacts his various creditors and tries to do a deal with all of them?
Certainly, communication at this point in time is key because of all the offerings that are out there at the moment as a result of COVID. you've obviously been able to have, you will have a chat with your bank, you'll have a chat with the creditors, and everyone's approach now during this time period is cooperation and assistance. Everybody wants to try and survive, and if everybody works together, there will be a good prospect of everybody getting through and surviving. So yes, the answer to that question is talk to people and see what you can do, see if you can get the support that you need. If the offerings that are available are inadequate or they're not available for some reason, then you're going to go back to the pre-COVID situation where you're going to sit down and analyze whether it's a rescue or if it's liquidation.
Okay. The second question, also for you, Colin. Is there a difference, and if so, what is the difference between a forced liquidation and a voluntary liquidation? And in these two scenarios, are there different implications for shareholders, directors, creditors, and employees?
The short answer is there really is no difference between a voluntary liquidation and a compulsory liquidation in effect, in implementation. So a liquidator will come in and he will do what he does ordinarily, whether it's voluntary or if it's compulsory. Voluntary is probably easier to achieve and quicker to achieve. Compulsory is via court order. For shareholders, directors, I don't think there's a difference. Employees, there's no difference, but there would be a difference if it was a rescue for an employee. Certainly, there's added advantages from an employee's perspective to going into rescue as opposed to liquidation.
For instance, what, Colin? What's the benefit to employees? Do they get more money or?
No. The bottom line is that in a rescue, employees are given certain preferences and they elevated effectively to a level where they try to be catered for and looked after. They cannot be dismissed unless they go through a formal process or by court order. And there's a lot of protections in Chapter 6 of the Companies Act in regard to employees. In liquidation, employees are automatically suspended on the date of liquidation. And effectively, if nothing is done with them, they're not engaged by the liquidator or they're not retrenched. After 45 days, they are automatically dismissed. So certainly the advantages for an employee are stacked up in regard to business rescue as opposed to liquidation.
Thank you. Okay, if a shareholder has provided a personal surety, let's say to the bank on a term loan, what is the best way for him to ultimately protect his personal assets if he suspects that his business may have to go the liquidation route? In this instance, for example, if he's a director and he's also a shareholder, are there any additional considerations that should be taken into account to minimize the risk of personal loss?
Our answer is no, really. Once you've signed a surety, and if it's a valid and binding suretyship, which I assume if it's given to a bank or a lender who's a proper lender, it's a binding and enforceable suretyship, and there's really very little you can do to try and cover yourself now. The Insolvency Act is stacked with provisions that look into situations where people do try and protect themselves, and there are sections in the Act which creditors are entitled to invoke, which would set aside or void those type of transactions.
Okay, so there's really not much one can do.
No.
If a business has cash available, do you recommend that it applies that cash to settle its bank debt and then perhaps sell off its assets to settle other creditors such as landlords and suppliers in circumstances where the serious financial challenges that it finds itself in due to COVID-19, the fallout continue to dampen its revenue for the future?
Again, the Insolvency Act contains all these provisions which allows a creditor who feels aggrieved if he sees other creditors having been preferred shortly before liquidation. So it would attract litigation, it would attract inquiries and that type of scenario if you do it. What you should do is now consult an expert, sit on your cash, and either decide whether to go into liquidation or into rescue, and then allow the cash to be utilized in a manner that would not attract any litigation or the invoking of any of the provisions to set aside all these voidable dispositions or preferences.
really what you're saying, Colin, is that there's sections in the Insolvency Act which prevent you from choosing which creditor you can pay and how you can prefer one creditor above the other, and that if you do something like that, it could be that transaction could be attacked. Is that
generally,
what you?
Yes, generally. If the creditor is secured, then obviously it would be harder to set aside a preference because the money would have gone to that creditor at the end of the day anyway. So you could pay your secured creditors, might still attract a bit of attention following on a liquidation or a rescue, but I wouldn't do anything of the sort. I would take a decision either to go into liquidation or to rescue or to approach your creditors and do some kind of scheme, then pay out and prefer creditors on the eve of it looks like a company going into some kind of restructure or liquidation or something along those lines.
Yeah, you see, it would be far more attractive for me to settle my bank because that's obviously where my personal surety is. And the other suppliers may not necessarily have me on the hook as a personal surety. But you're saying that even in those circumstances, if the bank is not secured, I run the risk that that transaction can be set aside.
Yes, I agree with you entirely. If I signed a suretyship, it certainly would suit me to discharge that debt using the company's funds, but that would attract attention on a liquidation. If the bank is ever secured with debtors, notarial bonds which have been perfected or special bonds, then the risk of that transaction being attacked or overturned subsequent to a liquidation is minimized.
Okay, thank you. Colin, what are the implications of a liquidation process if there are amounts owing to SARS?
There are advantages in going into rescue where SARS is the creditor because SARS is treated as a concurrent creditor in rescue, whereas in a liquidation, because of the statutory provisions of the Insolvency Act, SARS are preferent in regard to VAT, PAYE, SDL, and other things like workman's compensation, etc., which would flow through on a preference. So, yes, if you're looking at it from a SARS perspective only and your only creditor, and the company is or has a business which can be rescued, then that would stack in favor of a decision to put the company into rescue as opposed to liquidation.
Okay, if directors anticipate that a business may have to be put into liquidation, is there any way they could insulate themselves from legal and reputational risk that's going to be associated with that liquidation process? And is it appropriate or maybe wiser for those directors to resign in advance? Maybe just leave one director around to deal with the liquidation process, or should all the directors stay in place and deal with the liquidation fallout?
Ira, you can't really insulate yourself from the history. Whatever's happened in the company whilst you were a director, if there's something that was untoward, whether you resign or not will not help you at all. There may be other reasons for resigning. In other words, the company may at this point in time be trading recklessly, or there may be a fraud that's going on in the company that you don't want to associate yourself with. Yes, for those reasons you could resign. But if you think that by resigning you're going to protect yourself, or to use the questioner's words, insulate yourself, it's not going to help. What's past, what's happened, whether you've resigned or not, will come back to bite you if it's anything untoward.
Colin, just focusing on the one part of that question about the reputational risk, I think that there is, to a large degree, a reputational risk when a company does go into liquidation. But I think having regard to where the world finds itself now, with this global pandemic and the financial situation so many businesses find themselves in, and so many businesses going to be folding, I'm not sure that if your business folds as a result of the COVID pandemic, there will necessarily be the same reputational risk associated with it as in the normal course.
I agree with you, Ira. Traditionally, and in my experience, there's always two kinds of insolvencies. There's those where there's the dishonest director who's gone out of his way to steal money from his creditors and perpetrated frauds. Those are the insolvencies where actually the creditors are irate, aggressive, rude, and there's very little chance of there being any assistance from creditors in that scenario. The other, or the more, I think, prominent insolvency we're going to find now is that associated with bad luck. Example, COVID, where suddenly your revenue streams have been cut off and you've been sent home and you have to close your business. That's what you call the hard luck insolvency. Those are where the creditors and the banks and everybody else are more sympathetic towards the key players in the company, the directors, the shareholders, management, the employees. So in this current scenario, let me call it the COVID scenario, I think the stigma has gone. It will go for a time. It's going to be expected. It's going to be the norm that you're going to find a lot of people in the sad luck type of scenario, which caused the liquidation or the insolvency, and will be met with much sympathy from the suppliers, creditors, or those who are usually aggressive and try and go for the directors and management to recover their debts.
Thanks, Colin. Colin, in a case where a director is not a shareholder, what would that director's liability be in an insolvency situation? I suppose, could liability attract to a director in an insolvency if that director is not a shareholder, to phrase the question slightly differently?
Absolutely. Directors are always in the front line, whether they're shareholders or not. I don't think the fact that you're a shareholder will make any difference to your liability. If you've breached your statutory duties or your common law duties to the company, whether you're a shareholder or not, you will face the consequences of some irate creditor who wants to go against or go for you to try and recover the debts due by the company to his company or him or whoever.
Thank you, Colin. Danie, I've got a whole lot of questions I want to ask you now. Colin, I see there are still more questions for you, and if we've got time, I will try and come back and pose those to you as well.
Sure.
Danie, I think that before we start, though, maybe what I would like to do is just switch some of these questions around so that we can get an idea. I'm not a labor lawyer and I don't always understand all the terminology. So I'd like to know in general what measures are available to an employer to cope with the lockdown or the consequences of COVID-19.
Okay, so in terms of the Labour Relations Act, ultimately, if a company is suffering and struggling, it should and could impose or embark upon a retrenchment process in terms of Section 189 of the LRA. The very same provision requires, however, that it should always be as a last resort, and therefore there are other measures that employers can adopt or attempt to see if they can, by doing that, avoid the need to retrench. Those would be ordinarily the following. It would be layoffs, where the business closes for a period of time because it has no work, because its order book is empty, because it is cash strapped, whatever it may be. It can go into a layoff situation where they close for a month, 2 weeks, whatever it may be. Or it can impose short time, which can have any kind of parameters. You can have that people work half day, you can have that people work every second day, you can have that people work only 3 days work weeks or 4-day work weeks, any of those. You can also have salary reductions in order to try and remain viable. And lastly, which is something that has been quite topical in the last few weeks, is that the FSCA is quite amenable to employers taking a contribution holiday to the contributions they make in terms of pension and provident funds. That, however, would require a rule change, but they have said that they would expedite those rule changes to assist employers in that regard. All of these measures, however, are quite difficult to impose, and if you can reach agreement with your employees, that would be the best. Layoffs and short time are dealt with in certain of the bargaining councils for the larger industries' main agreements, and it's easier then, because then you just follow the terms of the main agreement, which would, in a sense, just require you to notify the unions and then give them a certain amount of time notice, and off you go. You can then impose layoffs or short time. The trouble, if you do not get consent of your workforce, is the two main remedies for employees who are met with these types of extreme measures short of retrenchment is that they could either if they have the ability, they could go on strike, and the strike remedy is quite immediately available to them, and it would be a protected strike, and you would not be able to dismiss them because they're on strike. Or on an individual basis, you may find that employees may say that whatever you've done, and particularly in salary reductions, that it goes to the heart of the employment relationship and has rendered the employment relationship intolerable, and therefore that it's a constructive dismissal. There are various other remedies, but they are more contractual, and I'm not going to dwell upon them here. That's in a nutshell, a mouthful, if you on what there is available.
And Danie, can an employee be forced to take leave during the lockdown period?
In terms of Section 20 sub 10 of the Basic Conditions of Employment Act, the employer can impose when employees take leave, and yes, as a result of that, employers can tell employees to take their leave. In any event, in the lockdown period where employees would not be able to tender their services, they would not be entitled to be paid because of the reciprocal obligation being that you first must tender your services, and once you've tendered your services and worked, you are entitled to be paid. And if you cannot do that, then no work, no pay would always apply. So employers can also on that basis do enforced leave taking as an alternative to no work, no pay.
Okay, so there was a question here, when can no work, no pay be imposed by an employer? When can you do that?
Well, no work, no pay usually is something that only rears its head where employees refuse their labour. They do not tender. And that ordinarily you would find in a strike situation. And that's why it's always, you will see everyone refers to it, even on TV, that the employer has said that during the strike, the principle of no work, no pay would be imposed. And that's usually when you would impose it. But at any time where employees are unable to tender their services, you can invoke the principle of no work, no pay. Difficulty is this: if an employee can tender his services and tenders his services, even if you have no work for him, you're obliged to pay him. Employee doesn't have to work to be paid, he must just tender his services. So if you have no work for your employees, then we're back into all of those remedies that I've discussed a little earlier. But then you would have to say, listen, I have no work, we're going into a layoff. I have no work, or I have limited work, we're going into short time, or I'm going to reduce your salary because I have no work for you. So that's then we're back into that game. But then again, as I've said, it would be preferable if you could get agreement from your workforce.
Okay, so one can reduce salaries and one can resort to a layoff for short time as a result of the current pandemic.
Yes.
Okay, Danie, if a force majeure event is implemented during the lockdown period, does an employer have recourse to partially lift the force majeure situation while the lockdown is still in force and allow only a portion of its employees to return to work as part of an allowed essential service?
Okay, a force majeure is an event which is beyond the reasonable control of a party and which makes the party's performance of its obligations under the contract impossible or so impractical as to be considered impossible under the circumstances. The question is quite a strange one, because if a portion of the workforce has been exempted as an essential service, then they would not fall under the lockdown, and the lockdown is the very reason why you can claim the force majeure. So it appears to me that if that portion of the workforce has been granted essential service status, they would not be part of the lockdown, and therefore the force majeure would not apply to them. Force majeure is not an all or nothing. You may find in a contract situation where portions of the contract has become impossible, but others not, and the force majeure would only apply to those that have become impossible.
Thanks, Danie. I have an employee on maternity leave. Whilst she was on maternity leave, the company decided to implement salary cuts to all its employees. Can the company impose on this employee the salary cut while she's already on maternity leave?
Okay, so there's a few things going on here. Firstly, people on maternity leave is not entitled to be paid. They must claim UIF, but a lot of employers allow for their employees on maternity leave to be paid. So the first question would be, is it a contractual obligation or is it a statutory obligation? So there's no statutory obligation to pay an employee on maternity leave, but if there's a contractual obligation, then we're back into all of these points that I've made earlier. And again, it would be quite harsh with someone on maternity leave if it's impossible to have some form of discussion before you impose it. And, you know, if the lady is in hospital and cannot be consulted, then it would be quite harsh to do a salary reduction under those circumstances, because all of these, what we term in labour law, unilateral variations of terms and conditions of employment, should be preceded by some form of consultation and discussion with the employees involved. So if you can't have that, even if it's via telephone, then I would suggest that you would be probably best served not to do a salary reduction of someone who's on maternity leave. But obviously, if you can have a communication and a discussion and attempt to reach some consensus, that would be possible.
Thank you, Danie. I've got a company that has already implemented salary cuts. During this time, however, I realized that I need to retrench my employees. Assuming that the company is now embarked on the retrenchment process, must I revert to the employee's previous salary, or can I proceed on the adjusted salary amount, especially if I discover this within 2 weeks of implementing the salary cut process?
Okay, that would fundamentally have to be decided on the intention of the salary cut. If the salary cut in like the period we're in now is a temporary measure where you would go back to the full salaries as soon as you are able, once the pandemic is over or the lockdown is lifted, then clearly if you consider retrenchments and have to pay severance packages, it would have to be on the full salary. However, if the salary cut is such a harsh measure and it is made plain that this would now be the new salaries going forward, and that increases later on would be on this reduced salary, and that the old salary would not exist at all, then the severance pay could be paid on the lesser amount.
So if I really just go out to my employees and I tell them, look, in light of the COVID, I've got to take measures to save my company, and one of those measures is we're going to have a reduction of salaries across the board, and everybody sort of agrees, and we get into that scenario, and then I find myself in trouble and I have to implement a retrenchment process. For the calculation of the severance package in those circumstances, I'm probably going to have to go back to the original salaries.
Correct.
Assuming that the company embarks on short time, can the earnings of the employee be less than the minimum wage?
In terms of the National Minimum Wage Act, Section 4, it is a mandatory requirement that you cannot pay people less than the minimum wage. Now, that minimum wage is set as an hourly amount of 20 Rand. So if you want people to work short time, you were going to ask them to work shorter hours, but the amount per hour cannot be less than 20 Rand. So you would have to pay 20 Rand per hour, even in the period of short time. You would not be able to go below the minimum wage.
A company embarks on short time and a few employees disagree to the short time. Can I then embark on a retrenchment and ring fence only those employees to the retrenchment process? I'm presuming that means, can I retrench the employees who refuse to take the short time?
This is a very, very difficult question, and it may seem quite harsh, because our law does not allow you to force people to agree to unilateral variations to terms and conditions of employment by threatening their dismissal. If you should do that, that is what is termed in labour laws an automatically unfair dismissal, entitling the employee to a 24-month compensation award by the Labour Court. That, however, does not preclude you from having a retrenchment process, but then following selection criteria in the generic manner of deciding who must go and who must stay on objective criteria, which would then may or may not include the people who refused, which would make it pretty harsh, but there's no way out of that.
Thank you, Danie. If an employee has to be placed in quarantine because the company is concerned that the employee may have contracted the virus, is that going to be considered sick leave?
Yes, the regulations that has been promulgated after the disaster had been declared has made that capable of being sick leave, and instead of a doctor's note, the employer and the employee will draft letters together to the UIF, and that would be considered sick leave for a period of 14 days.
And can an employee claim UIF if their employer is forced to temporarily close as a result of the pandemic?
Well, everyone must have seen this COVID TERS benefit scheme that is so topical. And in terms of that, if an employer closes either partially or fully for a period of not more than 3 months, it is entitled to claim from the UIF in terms of the TERS benefit for its employees who either have been put on short time or laid off, or no work, no pay, or now even with the recent amendments last week, even for those who have been forced to take leave. The requirement, however, is that the company must have fully shut for a period. It would not work for those companies that have carried on with their activities, even if it was to a limited extent. The UIF, the regulations require the employer to claim. The employer has to be fully compliant with the UIF and registered with UIF to be able to be entitled to claim, and the claim would then be administered and the money would be paid into an account which must be used to pay the employees. The minimum amount that would be paid is 3,500 Rand, and it works on a scale between 68 and 30%, where the lower level employees would get the higher percentage and the higher level employees, higher paid employees, would get the lower percentage. But salaries for the working out of the percentage is capped at just over 17,000. I think it's 17,170 Rand per month. So if you earn more than that, your percentage would still only be worked out as if you earn 17,170 Rand per month.
Okay, that's quite interesting. Danie, if a business has currently placed staff on leave without pay because there's no demand for its services and the business is not in a financial position to retrench its staff, I think we'll find there are many businesses in that predicament. What is the best way for such a business to deal with its staff? Do they keep them on leave without pay until the liquidation process is kicked off, or do they retrench them knowing that they have no capacity to pay them any retrenchment, any severance package?
In terms of Section 41, I think, of the Basic Conditions of Employment Act, it is mandatory to pay people a severance package of an amount of 1 week for each completed year of service of their remuneration. So one cannot go into a retrenchment process and not pay severance. So it would appear to me, and maybe Colin would be a better person to ask this question, that one shouldn't rather just let this business go into liquidation or business rescue, because then it becomes the liquidator's problem.
Thank you, Danie. I've got a question here which says we've recently gone through a Section 197, but will now have to retrench due to several duplications in roles. Am I correct in saying that we are allowed to embark on a Section 189 process as long as there are genuine operational requirements such as duplication of roles? And is there a cap on how long after Section 197 takes place that you are not allowed to retrench?
Okay, a few things. If this transaction in terms of which this business was bought or sold was reportable in terms of the Competition Act, the Competition Commission more often than not imposes time limits as to when retrenchments can take place. So if it is one of those, and the Competition Commission has imposed that after the merger there cannot be retrenchments for a year, 18 months, 2 years, whatever it may be, then obviously you cannot retrench. If there's no such directive in terms of competition law, then there is no preclusion in terms of the LRA that would suggest that you cannot immediately embark upon a retrenchment. The difficulty with these usually are that you find that the acquirer doesn't want to keep the people of the business that it has bought, and then it would want to retrench only those of the business that it has bought. Whereas what the law requires of you is to throw all of those people in a pot and then use objective selection criteria to choose those people with the longest service or the best skills to remain. And you can't just go piecemeal and just retrench those people that you do not want, but you can immediately embark upon a retrenchment.
Thank you, Danie. If a client needs to retrench staff, would it be a problem to start the consultation of this process prior to the end of lockdown? And could it be seen as fair if they offer retirement process to staff over 60?
Look, let's start with the retirement first. If your retirement age is different to 60, then it may become problematic because the employee would invoke his terms and conditions of employment and say that you're now dismissing him as a result of his age, and that is discriminatory. So it would be difficult if the retirement age is higher than 60. Obviously, if your retirement age is 60 or older, then you can just retire those people, and you ought to retire those people before you go into a retrenchment process. I've had this question in the last lockdown, in this lockdown period, on numerous occasions as to whether you can start a retrenchment process during lockdown. Obviously, there's no prohibition in the Act or in the regulations or in any statute that I could find, but the practical difficulties may become quite problematic in this sense. An employee is entitled to the representation by his union, and if he asks for his union to represent him, it may be quite difficult to set up that consultations. Obviously, if it's a person that you want to consult with and you can do it via one of these type of conferences or a teleconference, and it is possible to do it appropriately, then you should be able to start consultations immediately and during the lockdown. But if it is a process where you require union involvement or union or mass retrenchments where you have large groups of people who you would have to consult, and they would have to form a committee for such consultations, then I've advised that it would be enormously difficult to do that in the sense of the lockdown process, because it's going to be a process that may not be found by the Labour Court to have been appropriate consultations as to what is expected in consultations, which is toing and froing and at least giving the other party an opportunity and considering what they say and going back and advising why you disagree with them, and all of that is quite an interactive process which may not readily be easy to be achieved in terms of this type of technology. Look, if the lockdown goes on, it may be the only way.
Thanks, Danie. Danie, if after the legal lockdown a company goes into a shutdown due to a significant number of employees being infected, what's the legal position with regards to paying employees? There will not be enough time to introduce layoffs or short time due to the legal notice periods, yet the company has a legal obligation to ensure the safety of the employees.
That's a very tough question. Firstly, because I'm not sure whether it's a company that falls within one of the bargaining councils where they have certain specific requirements as to a notice period and a consultation requirement with its union. But if that is not so, there is no real other notice periods in terms of general application, other than you would have to at least consult and inform your staff that you are going to do this and the reason for it, and attempt to gain consent for it. There's a thing in labour law which is not often used, but I think we may see some of it in this pandemic period and the lockdown period, and that is what is referred to as the crisis zone cases, and that is usually where you have a strike and people go completely moggy and burn things down and break things, and you can't do a formal hearing and properly get rid of them after due process, where you're entitled under very extraordinary circumstances to dismiss them and maybe give them a right of appeal later because of the crisis zone. Now, I suspect something like this may have some kind of being able to rely on this type of crisis zone, where you say, I'm going into an immediate layoff period. I will try as best I can to follow whatever requirements may be required of me, but I can't do anything else.
Thank you, Danie. Danie, if a client agreed a multi-year increase with his employees, let's say a year ago, and the next increase is due now, and the business cannot afford to pay the increase, what can it do?
This is an equally tough one. In the big industries, they usually have these multi-yearly increases where they do so that they try and avoid to have to negotiate every year and avoid the possibility of strike action. It may be that this is such a game-changing event that one would be able to renegotiate in the labour sense. The labour sense has always been about fairness both to the employer and the employee, and I suspect that if a union would just refuse point blank to renegotiate these multi-year deals, an employer would probably be able to approach the labour court on some declaratory basis to seek to have it to have the deal set aside on the basis of these unforeseen circumstances. Very tough. It will all be new. We'll have to see what happens.
Thank you, Danie. Danie, if I do a salary reduction, do I have to do it to all employees, or can I do it with only some?
It would be very harsh not to do it across the board unless you can find some very specific justification, which would have to be something like essential services that you cannot afford not to pay in full, or some other reason where you can maybe differentiate that some people will be working full-time and others there's no work for them, and therefore you intend reducing their salaries, but not those who are working full-time and are very busy. But it's quite controversial.
Okay, there's a similar question, I think. It says, under what circumstances can you impose unpaid leave? Can you enforce unpaid leave on non-essential or non-key staff, for example?
Unpaid leave is usually where someone has run out of their leave entitlement and has to take leave for some or other reason, and then is willing to accept unpaid leave. It's not really something that you can impose. You must then rather impose no work, no pay if it's in the context of the pandemic or the lockdown. You would have to reach agreement on unpaid leave if you want to impose it on someone. It's quite a unique thing. It's not something that you can really impose. You should rather go for any of the other alternatives that I've put up.
Thank you, Danie. Can employers reduce salaries on a permanent basis? That's an interesting question. And if so, what procedure would they have to follow?
Well, I don't think there's much difference between a short period temporary reduction in salaries or a permanent reduction. It may be, for instance, that you have a certain very lucrative contract and that you lose for some or other reason, and your business will completely fail if the people remain paid at a certain level, and you have to reset your entire salary bands in order to make the business sustainable. Then I would suspect you would be able to, if you have some very specific event like this perhaps, where you can say we think that life beyond COVID is going to be quite different and we need to set a new salary banned for our business, then I think it could be permanent. You would have to attempt to reach agreement, and if you don't, you could impose it unilaterally and face those consequences, or you could attempt to persuade your workforce that that's an alternative to embarking upon a retrenchment process.
Danie, I've got a further question for you. What would happen if, for example, in our letter of employment, staff are forced to take leave, let's say over December, and they do take their leave? Can I now still force them to take leave as a result of COVID? I suppose many of them don't have any leave left.
In terms of Section 20 sub 10 of the Basic Conditions of Employment Act, if you cannot reach agreement on leave, the employer is entitled to impose when leave is taken. So with that, in that context, you can always, as an employer, impose when leave is taken. Situation may arise that you now impose that people take all their leave during this process, and then there's no leave left for them in December, and you would have to consider that carefully and maybe let them go into negative leave, even though that's quite a controversial topic in itself, so as to assist your workforce with that. It would be very tough, I suspect, but maybe I'm just going soft in my old age. It may be very tough to expect your workforce in December, if we all get through this, to take unpaid leave at that time.
Thanks, Danie. And what percentage of staff will need to agree before you have an agreement from employees? Do you have to have a unilateral agreement? Would it be good enough to have a majority? For example, if you want to put your employees on short time and you need to consult with them and get an agreement, what happens if I've got some employees who simply won't agree?
It's not, look, obviously unanimous assent would be great. If you don't get that, but you have a majority, I suspect you should then just impose it and let those who want to, who disagree, take you on. I also believe that in these times, the labor tribunals will look quite favorably upon an employer who has imposed these alternatives short of retrenchment rather than retrenchments on its workforce, and they would not look kindly upon employees who obstinately refuse to agree. It's not as if there's a statutory requirement that you need to have 50% plus 1 or 80% or unanimous assent. It's more of the contractual problem that you have, and that is you can always be met on a contractual basis by an employer that says that's not my contract, so you're now in breach of my contract. Difficulty with those claims from a contractual point of view for the employee is his claim would always only be limited to 1 month's notice, because from a contractual point of view, that's his only remedy. But from a labor point of view, he could claim all kinds of things. But in the labor sense, the labor courts would, in all probability, not find in his favor, given that it's an alternative to dismissal.
Thanks, Danie. Danie, if you have a situation where employees were physically absent from the office before lockdown, they weren't able, therefore, to collect their devices such as their laptops, data cards, phones, and therefore they're now not able to properly work on a remote basis. Is the business still obliged to pay them, despite the fact that they cannot actually render any work due to the lockdown?
I think we go back to the fact that if they can't tender their services, you can impose no work, no pay. If they had tried to get their stuff and couldn't get it, it may be different. But if it's their fault for not having collected their stuff, then it would be an easy decision to impose no work, no pay.
Thanks, Danie. Colin, I've got a couple of questions I'd like to put to you. I'll give Danie a break. He looks like he's had quite a run there.
Thanks for all the flack there, Danie. I appreciate it.
Can a company, Colin, sell off one of its major assets at fair value just before a business rescue or a liquidation? And what should the directors keep in mind before they sell off this asset? Or is it best to rather sell the major asset during the actual business rescue process? Okay.
The question posed was whether there would be a subsequent liquidation or rescue. Let's look at the rescue first. To sell off a major asset or undertaking of a company would require a number of formalities to be complied with, besides the fair value which the question indicates. There's special resolutions that have to be passed. There can't be any in the memorandum of the MOI which may contradict or prevent it. So it's quite formalistic. The easier method is to sell it during rescue, where these provisions would not apply if the sale is pursuant to an adopted business rescue plan. So instead of going through all the formalities of the solvency, liquidity, special resolutions, fair and reasonable, all the others, it is much easier if you do it through rescue, but it might be more costly because then you'll be paying the cost of the business rescue practitioner. So there's a balancing act here, and I think one would sit down and work out the commercial realities and work out for the company where it would come out on an account with more money if it did it on the easy way through the rescue process, or the difficult way the company would comply with all the formalities. It may, the question doesn't suggest that it may even be an affected transaction where you might need the TRP's involvement. So it sounds like it would be best and easiest to implement from a business rescue perspective. On liquidation, you'd have to go through the formalities of advertising the sale under Section 34 and setting out the time periods and settling the debts of the company if a creditor reads the advert and demands that the debts be paid, etc. So taking everything into account, my answer is do a balancing act from a financial perspective to see whether it's easier to achieve in a rescue and you get a higher return, then do it.
But Colin, legally, there's nothing, if I'm selling at fair value, is there anything which could have that transaction set aside, or I'm not doing anything wrong?
No, I agree with you, but there may be a creditor who disputes that your value is fair and may then want to have a fight with you in a court and bring experts to show that your value was not fair and that you'd sold it off less than arm's length and you'd sold it to a family member or a friend or to a company in which the director himself is involved. So to avoid all those kind of issues, you would be safest doing it through the rescue route.
Thank you. And then Colin, in what circumstances does a creditor land up paying in instead of getting paid?
There's no risk in a rescue. The risk only arises in liquidation. In liquidation, you're deemed a contributor. In other words, you have to pay in. If there isn't sufficient assets or cash to discharge the administration costs of the liquidation, then the liquidator would levy a contribution on the creditors who have proven claims. So you should only prove your claims for your clients, or if you're a creditor, you have your claims proven if it's clear that there won't be a contribution being levied by the liquidator. And a person who brings about a compulsory liquidation is a deemed contributory. So if there are no claims proven, the liquidator or the trustee would go against the petitioning applicant, if there is one, to get the costs that can't be recovered from cash or assets in the estate. Ira, unmute.
Thank you.
When
lockdown ends, Colin,
yes,
and my business has no cash, what should I do?
Are there many things you can do before looking at the formal route of liquidation or business rescue? You've got to consult someone who's up to speed on all the incentives that have been offered by government and by private sector and from banks. I would exhaust all those routes first, and if they prove to be inept or inadequate and you still have the problem, then you must follow the route of either liquidation or solvency, because then you will not have any choices.
Thank you, Colin. We've still got 5 more minutes. Danie, I've got a couple of new questions that have come in for you that I want to pose to you.
Hope they're a bit easier.
If an employee was extremely ill before lockdown, can one assume the employee continued on sick leave? Can one just make that presumption?
Well, if he was on sick leave already, I would assume that he would remain on sick leave, yes.
Thank you. Does the IRR applied by the UIF regulations, applied in terms of TERS, have the effect of excluding benefit payments to employees who earn above a particular threshold? I'm not sure if that's a question we can answer without some research, Danie.
Look, as I understand it, and it is quite difficult, a lot of that regulation is not a modicum of clarity, but that top end amount, which I've set out earlier of the 17,000, is like a ceiling. Even if you earn more than that, you will only benefit to a percentage of that. So if you have that sliding scale from 38 to 60%, and 38 is for the higher paid employees, it would appear that someone who earns 17,170 Rand a month would get 38% of that from UIF for 3 months, and someone who earns 3,500, which is the minimum wage, would get 60% of that. It's difficult because I have a client who yesterday got his payment for his entire workforce, and the amount was a straight up 3,500 Rand per person. So it's not as if the UIF at all applied that sliding scale, but it seems to me as if you could still be entitled to this benefit even if you earned more than the 17,170. You will just be capped at that.
Thanks, Danie. If a company has reduced salaries but hasn't actually shut down, will the UIF benefits still apply?
As I've indicated earlier, the requirement in the amended regulations that we have found, it went from you have to show that you're in distress, then they took that out and they left that you have to have been shut down completely for a period of 1 to 3 months before you can claim, some wording to that effect. So it appears to me if you have manfully struggled on, tried to keep your business afloat, contradictorily as that may be, you're not going to be able to claim.
Okay. Danie, this question is the party posing the question says they have a situation where they are likely to have to curb the hours and therefore that they have to pay the lowest level workers, but they feel it's ethically correct that high level management also cut their salaries in line with the low level. For some, it's easy to be put on unpaid leave. For others, we need them to tender full-time services. Can a cut be made to their salaries for some time?
It's a difficult question because there's parts of it that I find a little confusing. But as I've said earlier, I think morally it would be better if you have a salary reduction across the board that everyone feels they're in the same boat. I can understand, however, that if you're going to have short time, that you may have short time for certain people and not for others, where they are essential or critical and have to work full time. And then I think it would probably be easier to make that differentiation than reducing salaries, but not reducing everyone's salaries.
Thank you, Danie. I think this will be our last question, and that is for you, Danie. If an employee was ill before lockdown, would one be able to follow an incapacity route as he was not, because the person was not able to return to work for some time due to COVID?
Incapacity would depend on various circumstances. You would have to understand the reason for incapacity. Incapacity is a topic completely of its own. And I would not want to go into it too much here because it would depend on whether the incapacity resulted from something that happened at work. You would have to inquire and investigate through medical evidence as to whether the person would get better, would not get better, how long it will take, can you accommodate the person in a lesser job, all kinds of things before you can even consider going onto an incapacity dismissal route.
Thank you. Colin, I'm going to put the last question to you, and then there's one that I'm going to take. And then, guys, we're going to have to call it a day here this morning. Colin, does a business rescue practitioner have to convince creditors that assets disposed of were essential to be sold and that they were sold at fair value?
Good question. Ira, a business rescue practitioner can sell assets under 3 circumstances. One is in the ordinary course of business. So if he's selling stock, he has the power to do so, and one would assume then that in the discharge of his duties, where he could be held accountable for gross negligence, he has sold them at the right value. Fair value must take into account all the circumstances applying at the time. If you're dealing with second-hand clothing, you can imagine there won't be a good price achieved, but if you're dealing with high fashion items for which there's a demand, you probably would then get the right price. So fair value depends on the facts and circumstances, and a business rescue practitioner worth his weight would definitely ensure that he's done his homework and he's made the necessary inquiries to ensure that when he sells the stock, he's done so at a proper and fair price. The second circumstance under which he can sell is in a bona fide transaction at arm's length for fair value approved in advance and in writing by the practitioner. So if he's selling assets or anything else, again, he would have to have them valued by a sworn appraiser or a proper valuator. He would have done his homework, and you must assume that if he's a proper business rescue practitioner, he's satisfied himself that the value has been achieved and he's got the right price. The third is in contemplation or the implementation of an accepted or an adopted business rescue plan. And there, once it's adopted, one would assume that either as part of the plan to rescue the company in the classic sense, that the company will be solvent afterwards, he's getting the right price, he's received a number of bids, and he's taken the highest bid or the bid that makes the most sense. Alternatively, if this is not possible, as the Act says, and he's doing the alternative wind down, in other words, what we would call an informal liquidation, he has under those scenarios then also satisfied himself with valuations and the like that he's getting the right price. So to answer the question quickly, he doesn't have to satisfy anyone other than himself, and that if he is questioned on it, he has all the backing or the audit trail to show that he did the right things, got the valuations, and made sure that he sold it at the right value.
Thank you, Colin. So I have a question, and that is whether or not the session has been recorded and whether the recording will be available. I believe that it has.
You get all the tough questions, Aaron.
I've got the toughest question, and I didn't even know the answer, Colin. But apparently the session has been recorded. And if anybody would like further details or a copy of the recording, they can contact our marketing manager, Renelle Berry. She's the lady to whom you replied to get the link, and she will be able to tell you how to access it or provide you with a copy. So I'm afraid we're out of time. I want to thank you all for your attendance and participation, and to my colleagues for giving up their valuable time in answering the questions today. If any of you require further assistance, just remember, we're only a phone call away. Thank you all, everybody. Thank you for your attendance.
Thank you.
Thank you.